Procedural. I've been contacted by Mr. Mgomezu to stand in for him.
Okay.
He might come before or during the proceeding. He's engaged in another court matter.
Okay. Mr. Ramsipidi, you're laughing. Yes, ma'am. But have you told accused number 1 that you are standing in for you?
Yes, I spoke.
Okay, fine. Yes, ma'am.
Thank you, my lord. My lord, yesterday we paused at paragraph 1.7 of the heads of the state, wherein I wanted to check the record for the period of the 1st of August 2023, page 11. My lord, I'm now in possession of the record that has been referred to in this paragraph. My lord will see that from paragraph 1.7 of the state's heads of argument, it says, in question asked in clarification by the court, his role as an analyst became clear when it remarked that because, like he says, when I understood him to say that the investigation is ongoing and giving him an analyst some of the downloads, even section 205, and he used the information to try and identify the persons. My lord, that is the reason I had to go back to the transcript record, and I was able to find or to locate, my lord, that actually what was explained into the record under the questions by court is reflected on page 11, line number 10. This is the answer. These are the remarks by His Lordship, my lord, that are being quoted here. On line number 10, page 11, for the transcript of the 1st of August 2023. The court remarked as follows, my lord. Your colleague who was here, did she tell you about the evidence which was led by this witness in your absence? If you want to read that evidence from the record, we can give you that time. Because like he says, when I understood him to say that the investigation is ongoing and giving him as an analyst some of the downloads, even the section 205, and he used that information to try and identify the persons who are associated with the numbers, which they found from the downloads. And the response, my lord, by Colonel Stein was that that is correct. In other words, he's correcting the submissions made by the court.
The court doesn't make submissions.
My lord, the clarification, because it was questions put on clarity.
I see.
Then he already clarified that it was a result of the downloads, my lord. My emphasis is that, my lord, there is no need to call Colonel Stein because he had already confirmed that what he used is because he found the information from the downloads. Even the section 205, and he used that information to try and identify the persons who are associated with those numbers. He has explained himself, my lord, to say he used both.
But what he didn't say is that he used a program called Excel, which Mrs. Tellingham says that's what was used in order to get those, as Mr. Manisi calls them,
my lord,
materially incorrect numbers.
Incorrect numbers?
Yeah.
My lord, it is my respectful submission that if that is the case, Colonel Stein, at the time when he was testifying, he knew he had that information, my lord.
No, he didn't say it. Even if he knew it, he didn't say it.
He didn't say it, but that information, that part of portion of evidence was available to the state at that particular
Okay,
time.
fine. That's another issue there. It's fine. Okay.
When he was testifying, my lord.
Okay.
Yes, and he did not mention that when he was given that opportunity.
Okay.
And the state was also, my lord, given time to re-examine in order to clarify any other issues. And that was never done by the state to clarify that portion of evidence, my lord.
Okay.
And therefore, my lord, it is my submission that therefore the witness cannot be recalled to come and correct or to come and bring evidence which was available at the time when he was testifying. Thank you, my lord.
Okay.
And then I'll move on, my lord, to paragraph 1.8. And then we'll go to the same transcript of the 1st of August 2023, page 6. The state says, my lord, or submits as follows in paragraph 1.8. It is respectfully submitted that the state ought to be allowed to recall Colonel Steyn to clarify the issues of the two calls, to clarify whether the source of information of the two calls is cell phone downloads or section 205. I have already referred the court to this clarity which had already been given by Colonel Steyn, and the information that appears on pages 26 and 27 of his affidavit. My lord, if we go on page 6, line number 16. Line number 16, my lord, under Mr. Steyn, it says, that is correct, but also I can also mention, after I've received the information from Brigadier Geninda, I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. Link here, you can see on one of the pages here on the screen. In other words, my lord, my submission is that what the state is asking has already been done. Steyn had already given this explanation, which is reflected on page 6 of the transcript record. That I threw it into the AMB notebook database, and then the linkages come with the section 205 and the cell phone downloads. Like here, you see on the one of the pages here on the screen, I think he was displaying it for us at that particular time. Therefore, the state cannot be given a second time now to come and repeat the same evidence which has been clarified on the record, my lord. Going further, my lord, on paragraph 1.9, in re-examination by the state, I won't read everything, my lord, but I'll just go to where I want to put emphasis and put it to the attention of the court. It's under my cross-examination. Also, my lord, it's under the examination by the state. In re-examination by the state on the 1st of August, page 14, my lord, we are on the same transcripts, page 14 to page 15. This was examination by the state. It's on line number 6. By Mr. Baloyi. You were asked by Advocate Mshololo as to how you established that the number which ends with 202, the complete number is 0733059202, made contact with the number belonging to Ms. Kelly Kumalo. You testified that you used the information derived from the investigating team as well as your own searches. It's coming from the words of the state that you have testified that you used information derived from the investigating team as well as your own searches. Can you just clarify the court as to what those searches entail? In other words, my lord, the witness, Kenneth Stein, had already been referred to by the state in respect of the true transactions that we are dealing with, and Kenneth Stein had already responded, my lord. Mr. Stein responded and said, I took the SAPS, I mean section 205. I can show that to the court. This is the way we receive it from the service provider. And we throw all this information in a central database. This is the response, my lord, from Kenneth Stein. And then on my AMB notebook program, I can go for a search, then I put it in the number which I received from the investigation team. I can put it in any number, then the program will pick up the number and point it out to me. That's the explanation which has been given, already been given by the same witness, my lord, the state intends to give. And then going down, my lord, to paragraph 1.13 of the state submissions, it also says an explanation by Lieutenant Kenneth Stein might foreclose the request of accused number 3. Oh, no, sorry, not that one, my lord. But I'm on paragraph 1.2.12. This is not about the evidence being favorable to the state or the evidence or the defense, but about the truth being determined in order for the court to arrive at a just decision on the case. The evidence is on record. It's clear, my lord, the explanation on the nature of the two transactions in dispute before this court, in which the state seeks clarity, has already been given in many respects, my lord, but I decided to quote this few and to refer this quote to this few that has already been explained by Kenneth Stein. So what more does the state want Kenneth Stein to come and say? Because he has already clarified, especially on page 14, the paragraph I've just read, as to how he analyzed. He said, I took the SAPS, I mean section 205, I can show that court. This is the way we receive it from the service provider. She's saying that I took section 205, which I received from the service provider, and threw all information in a central database. My lord, I cannot repeat it again because it's on record. It's evidence that is on record, my lord. Moving further down, my lord, on paragraph 1.15, recording of a witness is a rule of practice to ensure that justice is done. It is neither the re-examination of a witness as provided for by section 166 of Criminal Procedure Act 51. It is more based on section 173 of the Constitution. The recalling, my lord. And then when I look at the provisions, my lord, of section 173 of the Constitution, which I will quickly go through it with the leave of the court, my lord. Section 173 refers to inherent powers, and it reads as follows, my lord. The Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa, each has inherent powers to protect and regulate their own process, and to develop the common law taking into account the interest of justice. My submission, my lord, is that looking at the interest of justice, the interest of justice, my lord, I submit with due respect, does not allow the recalling of a witness to come and repeat evidence, explanation that has already been testified in court. Because that will amount to an unfair trial on the part of the defense case. Paragraph, the next page, my lord, after page 3, which is page 4, and it says, my lord, so the interest of justice is a prime consideration in deciding whether a witness should be recalled or not. This power is already vested in Section 167 of the Criminal Procedure Act. I've already addressed on the purpose of section of the provisions of Section 164 yesterday, that it's only invoked at the state of the court, not at the instance of the state. The interest of justice, my lord, I submit, does not allow the recalling of a witness to come and repeat himself, to come and repeat evidence that is already there on the record. The only reason the state now wants to recall this witness is because of the contradiction which has been raised during the cross-examination of other witnesses. And therefore, my lord, the interest of justice does not allow the recalling of the witness to come and clarify contradictions which arose during the cross-examination. I submit, my lord. And further, my lord, on the same paragraph, if I can just read it complete, which states that the court may at any stage of the criminal proceedings examine any person other than the accused and may recall and re-examine any person already examined at the proceeding, and shall examine or recall and re-examine the person if the evidence appears to the court to be essential to the just decision of the case. The witness cannot be called to come and lead evidence. The evidence that the state intends to lead now is irrelevant, my lord. I submit with due respect. It's a repetition of the evidence which is already on the record. And then further to that, my lord, also, I would like to make few submissions, my lord, in the leading case. Of R versus Hepworth, my lord, 1928 AD 265 at 277, on the issue of the interest of justice. My lord, I'm referring on paragraph at 277. That's why I'm saying it's a leading case. It's a well-known case in this court, my lord. But it is all more important in view of the exhortation of fairness. I quote, my lord, what has been referred to by Lewis J.A. in this case, when he says, a criminal trial is not a game where one side is entitled to claim the benefits of any commission or mistake made by the other side. And a judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. That's where my emphasis is, my lord, that I want to submit before this court. That, my lord, justice will be done if the state is allowed to recall a witness in order to rectify the contradiction which has been created during cross-examination. It further says, my lords, the judge Judge's remarks not only apply in consideration of this section, but are particularly opposite to it. How the dual role of a person who decides and at the same time administrators of justice is fulfilled calls for sound judicial discernment. On one hand, the court searches for the facts, but on the other hand, a perceptibly even-handed trial is the goal. How far a court will go to repair the carelessness of a party in a matter of sound common sense in each case. Close quote, my lord. My lord, my submission is that what the state is intending to do here, as I have raised yesterday, my lord, to say initially the state indicated that Steyn was no longer available. The state wants to close the gap. The state wants to close the lacuna on the evidence of cell phone records which has been presented before this court. My lord, an injustice has already occurred wherein Lieutenant Colonel Gous was called to bring new evidence when the trial had already started. When the state realized that there was more information of which Colonel Steyn was still supposed to bring to this court, the state indicated that Colonel Steyn was no longer available. However, he is now available. It raises doubt, my lord, whether Colonel Steyn was not available from the beginning. And now, my lord, the same Colonel Steyn is called to come and repeat what I have submitted before this court. The explanation, the clarity the state that is seeking has already been given, my lord. Therefore, it is my submission, therefore, that injustice will not be done if the application by the state is granted on those bases, my lord. My lord, also, I would like to refer this court to the transcript of the 17 April, of the proceedings for 17 April 2024. Page 37 and page 38 of this transcript record, my lord. Line number 18 to 25 on page 37. 17 April. The state here, my lord, was page 37, line number 18, under Mr. Baloyi. I just want to refer you to the evidence of Colonel Steyn as appears on page 75 of the proceedings of 27 July 2023. Just to hear what your comment is, my colleague will just show you the relevant page. It will be page 75, line 6. It is the same page 23, then my next point during the analyst, I discovered that Ms. Kelly Kumalo, with a number which she gives, she received a call. This is coming from the state, my lord, that she received a call. And this is the clear evidence that Ms. Kelly Kumalo received a call from Ntulinkani with the number 073 305 902, and he goes on to say it belongs to Fisoguhle. What is your comment regarding that number? So, my lord, in other words, the state has already placed this evidence. The state has already placed the nature of the calls. The state has already placed the nature of the transactions. that took place between these two numbers, as it is being alleged by the state, my lord. And the response by Lieutenant Colonel Gous, he says, thank you, my lord. The number is found under XDS, so some or other time accused 5 must have given the number out as reference on the credit. In other words, that's the response when the state invited the witness, Lieutenant Colonel Gous, to comment on this call, on the nature of this call. And further, my lord, the submissions that were made by the state on the same page 38 under Mr. Baloyi, then he continues on page 76, proceedings of 27 July. If, my lord, if he says, then he continues on page 76, proceedings of 27 July 2023, line number 9, he is referring to the evidence of Colonel Steyn, that Colonel Steyn has already testified regarding this. It says that start date of the call was 2 August 2014, and the time was 22:40, and the duration of the call was 110 seconds, close to 2 minutes. She received a call from the other party, 073-305-90002. What is your comment on that? Lieutenant Colonel Steyn was referred to the evidence of Colonel Steyn regarding the same issue that the state is seeking to recall the witness to give clarity on. Going down, my lord, to line number 19 on the same page, also under Mr. Baloyi's. Then Colonel Steyn continues on page 77. So it means Colonel Steyn has testified on page 77, proceedings of 27 July, line number 8. From line 8, it says, in other words, she received a call, and the call was on 15 October, which is the second transaction, my lord, 15 October 2014 and 17:33:57. The time of the duration of the call was 98 seconds, a minute and a half more or less than the other party. It is 073-305-9202, which belongs to accused number 5. He says the tower reception area was 2G Ivory Farm, somewhere in Limpopo. What is your comment? The clarity has been sought regarding the evidence of Colonel Steyn, and the state has already placed on record the nature of these two transactions when that clarity was sought. And then further down, my lord, on page 39, line number 11, also under Mr. Baloyi, just finally, he repeats the evidence on page 82 on the same, during the same time sitting on 27 July. In other words, he's referring to Steyn that he repeats the same information. From line 24, Mr. Steyn, page 82, July 2024, the second sentence from the bottom. Okay, thank you, my lord. The next entry is at 17:33:57. Received a call. It's clear, the answer is clear, my lord. He received a call from number 073-305-9202. Is the number of the suspect 5. And while he was still in the tower reception area, Ivory Park. What is your comment to that? So, my lord, I can read into the record the reference which has already been made, the evidence which has already been placed before this court regarding the circumstances under which these two calls were made. And therefore, I submit, my lord, that it is not in the interest of justice that the recalling of Colonel Steyn is granted, and it will amount to it will cause a prejudice to the side of the defense, and it will amount to an unfair trial on the side of the defense, especially of accused number 5. Those are my submissions, my lord, as the court pleases.
Okay, thank you. Can you summarize for the accused the arguments by their counsels, Mr. Mnisi, Malo, and Ms. Mshololo?
izabe ezibekwe umshushisi zokuthi-ke kuphinde kubizwe uKenneth Stein ukuthi eze la enkantolo njengoba umshushisi esefake isicelo sokuthi akeze ukuthi azochaza ukuthi lokhu akubeke enkantolo bekuwukuthini ngoba khona okungathi akufani. Kuthiwa-ke lana konke lokho kungabekwa ngaphambi kwenkantolo ngesikhathi sokuthula izimpikiswano nezincomo, kusho ukuthi-ke yilokhu abakubiza ngokuthi ama-argument, ukuthi konke lokho kungakhulunywa ngesikhathi-ke sama-argument, ngoba lana kuthiwa-ke okwehlukayo ukuthi kukhona-ke la kuthiwa khona umsolo wesihlanu efonela inamba egcina ngo-358 okuthiwa ikaKelly Khumalo. Lapho ubonakala khona ukuthi kuthiwa umsolo wesihlanu noKelly Khumalo ibona-ke abo-mastermind noma ibona ababehonqaphambili futhi nokuthi ibona abaletha laba abanye kuleli cala. Kuthiwa ku-page 74 kwe-affidavit ka-Lieutenant Kenneth Stein kuthiwa lapha inamba le kamsolwa wesihlanu yafonela uKelly Khumalo, kanti okunye kubonakala sengathi cha inamba ka-Arthur Mafokate eyafonela uKelly Khumalo futhi akuyena umsolwa wesihlanu. Manje-ke ngalokho-ke ukuthi akunasidingo sokuthi kuphindwe kubizwe uKenneth Stein ukuthi azochaza ukuthi ngaphansi ka-section 205 akatholanga ngokusemthethweni, futhi-ke uBrigadier Ginenda usafanele azochaza ukuthi kwenzeke kanjani ukuthi kube nezinto ezivela la enkantolo kuwukuthi azichazeki kahle ukuthi zihlangana kanjani. Ngizongena futhi lana kuloko kubekwe umshololo ukuthi uthe lapha umshushisi uveze ukuthi ngaphansi ka-section 167 kuyabonakala ukuthi ufakazi usengabuyiswa futhi azolekelela inkantolo kokunye mhlambe nokuthi ijaji lingakwazi nalo ukuthi libize uKenneth Stein. Kuthiwa-ke lokho bekuzolunga ukuba umshushisi wayengezanga ukuthi abize lofaka ukuthi umshushisi esembizile ufakazi aphinde futhi azomletha futhi. Manje la kuthiwa uKenneth Stein kuthiwa-ke uKenneth Stein lana uqala nje kwaqala kwathiwa uKenneth Stein akatholakali, yikho-ke kwenza ukuthi manje kuze kubizwe uhost ukuthi eze kuzoba uyena oqhubekayo, kodwa-ke manje sekuthiwa uStein useyatholakala manje. Kuthiwa amalungelo ngaphansi komthethosisekelo athi uma kunobufakazi obusha ufakazi ubizelwe ukuzolu akunabufakazi obusha ufakazi lona obizwayo manje ubizelwe ukuzolungisa amaphutha akhe. Iphutha leli elokwehlukana kobufakazi bukaStein nokuba kwalethwa umama uVithilinga. Lapho-ke umsolo wesihlanu kuthiwa washaya ucingo eshayela uKelly Khumalo, kodwa-ke umama uVithilinga ngimechazela uthi cha akukho lokho kubonakali kuyinto ekhona la kuma-record ukuthi kwake kwenzeka, okusho ukuthi akudingeki ukuthi ubize ubaba uStein ukuthi azophinda ubufakazi bakhe ngoba besekhulumile. Kuthiwa la uStein akazange asho ukuthi wasebenzisa i-Excel, okuchaza ukuthi manje uma engakushongo lokho usengabuyisa ukuthi azochaza ngoba le ndaba le-Excel akazange ayibeke phambi kwenkantolo. Bese kuthi uma sephendula kuthiwa no wayenalo ithuba lokuthi angakuveza lokho, kodwa-ke umshushisi akazange azame ukuthi amsize ukuthi akwazi ukuchaza kabanzi ukuthi kuzwakale lawo manje kusho ukuthi angeke alethwe futhi ukuthi azokhuluma into asayishilo ngoba kuthiwa yena uthi yena wathatha bonke yonke-ke le information ayithola le kwa-Vodacom wayifaka kule ncwadi kuthiwa i-MB notebook i-program le kuthiwa-ke and yase-ke ikhipha and wathi-ke angafaka nanoma iyiphi inamba khona lapho umifaka leyo namba lapho iyakwazi ukuthi ikhiphe lokhu abadinga ukuzwisisa ngaleyo namba manje kuthiwa ubaba uStein konke lokho bese kuchazile and futhi-ke akudingeki ukuthi angaphinde abuye futhi ngoba lobufakazi konke lokho sebuqoshiwe and futhi-ke lo lwazi abaludingayo selukhona luqoshiwe phansi ukubizwa futhi kukafakazi kuzobe kungasizi lutho base-ke kuthiwa-ke indaba ka-section 173 iqome ngitho ekutheni akusho ukuthi ufakazi kufanele ukuthi aphinde azosho lokho asekushilo injongo yobulungiswa ukuthi ayivumi ukuthi ufakazi azophila kodwa kufanele eze uma ukuthi khona okusho inhloso yobulungiswa inhloso-ke kamshushisi kuthiwa eyokuthi kubizwe lo fakazi lo ukuthi azothi abheke lamaphutha lawa ayenziwe lapha kuzama ukulungiswa lamaphutha ngoba kuyabonakala ukuthi khona iphutha elikhona bese kubhekwa icala le-R versus Hepworth lika-1929 lapho ekhuluma khona ngenjongo yokulungisa enkantolo kuchaziwe kabanzi-ke lokho bese-ke kuthiwa uKelly Khumalo khona i-call ayithola evela kungathi kuthiwa uNtuli kodwa-ke kuthiwa lokho fakazi sebabekwe enkantolo manje incazelo engalethwa eyacelwa siyatholakala akuyona incazelo futhi ezoba incazelo entsha usechazile ufakazi okusho ukuthi akusadingeki ukuthi aphinde alethwe enkantolo ukuthi azophinde achaze lokho asekuchazile. As a court, please.
Thank you. Yes, any re-examination, if any? Mr.
As the court pleases, my lord, the state just wishes to respond to one or two issues raised by my learned friends. My lord, all that my colleagues did was to take the state heads and then to criticize them. However, at the heart of the criticism of the state's argument, there's this golden thread, my lord, that they categorize the evidence of Ms. Fathillingham and Colonel Stein regarding the two calls as they put it, my lord, as a contradiction. We submit, my lord, that this demonstrates a fundamental misunderstanding, as we printed out in our heads, of the nature of and we say this with the greatest of respect, this demonstrates the fundamental misunderstanding of the evidence of Ms. Fathillingham and Colonel Stein. We submit, my lord, with the greatest of respect, that there's obfuscation of the role of Ms. Fathillingham as a forensic officer of a service provider of call data with the role of Lieutenant Colonel Stein as an analyst. An analyst of an instrument, a cell phone, and accessing the downloads on the phone to which the service provider doesn't have access to these downloads. It's only Colonel Stein as an analyst who's got access to these downloads and who can testify about it. Now, my lord, to then categorize the evidence of the two witnesses as a contradiction on this point, as we've argued, my lord, demonstrate a fundamental misunderstanding of their evidence, and Colonel Steyn is available, my lord, to clear up this misconception, to clear up this misunderstanding. And as we've submitted yesterday, my lord, it's in the interest of justice that he should be recalled to come and clarify this aspect so that we are all on the same page. And my lord, it is this fundamental misconception that has led to him being accused of fraud, of uttering, and it is this fundamental misconception, my lord, that has led to this personal attack on Colonel Steyn. And the state views this attack in a serious light, so much so that we had to drag him out of retirement, mindful of what Advocate Mshololo said. He's retired, my lord, but the allegations that have been leveled against him are so serious that they cannot be left unchallenged. And even if you know, he's in retirement with all the old age ailments, we had to drag him out of retirement, my lord, to come and clarify these issues, because it's in the interest of justice, my lord, that they be clarified. We've been criticized, especially by Advocate Mnisi, that we should have dealt with these contradictions. But as we've just indicated, my lord, that viewed in the proper context, these are not contradictions. Each is testifying about the information that is applicable in their area of expertise. Lieutenant Colonel Steyn concluded his evidence on the 1st of August 2023, and Advocate Nisi was referring to Exhibit J1, the statement of Ms. Faithillingham, which clearly states that it was deposed to on the 16th of May 2024. So this, the evidence of Ms. Faithillingham came much later after the conclusion of the evidence of Colonel Steyn on the 1st of August 2023. Mr. Ngumalo argued that these are issues that can be addressed in argument, but we submit, my lord, that if there's such a fundamental misunderstanding of the evidence of the two witnesses, this is the issue that cannot be addressed during argument. We therefore submit, my lord, that the application ought to be granted. Advocate Mshololo said, argued that the state is asking the court to invoke Section 167. On the contrary, my lord, we have stated clearly in the heads that this is a rule of practice. We have, in the meantime, found that the case that the court was referring to of David King, case number 86/09, and judgment was delivered on the 8th of March 2010 by the Supreme Court of Appeal. And what the court said in this judgment is already contained in the heads of the state. On page 4, paragraph 5, the court said the following: there is no such thing as perfect justice. A system where an accused person should be shown every scintilla of information that might be useful to his defense, And discovery in criminal cases must always be a compromise. And this is the portion that we quoted in our heads. Fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it impracticable to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems. We submit, my lord, with the greatest of respect that this is an instance where the interest of justice trumps any other consideration. When Advocate Mshololo referred to the fact that the state is invoking, or is asking the court to invoke Section 167, we merely quoted Section 167 to indicate, my lord, that the application of the state is not an unusual occurrence. There's already provision for such a procedure in our law. We therefore, my lord, request that the application be granted.
Yeah, that's for my education, if there is a lack of it. Can legal representatives, meaning the state, can the state and also the defense invoke Section 167 or 186 and persuade the court or extol that persuasion to the court to say, the court is entitled or can invoke Section 167 or 186, not out of its own mero moto. Are you with me?
Yes, indeed, my lord.
Is it legal? Let's hear Mr. Ngomezulu first or Mr. Miyeki first.
Yes. Yes.
Can litigants, represented litigants by the state and by the prosecutor and by the defense, implore a court to exercise its own?
I hear the court.
Oh, you have heard it?
I hear the
Thank you.
My lord, in all the cases that we researched yesterday after this application was made, actually they indicate that it is actually the court that can invoke that section to recall a witness that has not, to clarify any evidence or to clarify any issue that has arisen during the...
Yeah, I've heard you, but you see, you're investing the logic.
Yes.
I know it is, the Act says I can do it.
Yes.
167
but,
and 186. But can you, because you feel your client is being shortchanged.
In terms
and then
of
this judge is so stupid, he doesn't see this point.
In
And you make an application that, judge, invoke Section 167.
In terms
That's
of
what I'm asking.
In terms of the case law that is available, my lord,
Yes.
that is unknown. It is
Unknown,
not,
okay.
I have not come across case law that actually shows that the state or the defense can actually recall the witness to close the lacuna in a case.
Okay, Mr. Mnisi, sorry, Ramsepidi, you agree with your colleague?
As the court pleases, my lord, stricto sensu, it
Okay.
says, in the strictest terms of the Act, it says the court may recall a witness for clarification purposes, my lord. However, in answering the court's question, in the Shabir Sheikh matter, it was the defense that recalled a witness for clarification, my lord.
Okay, fine. No, I'm aware of the case. Mr. Mnisi, Educate me.
By convention, my lord, I think there is no impediment from one of the litigants to request the court, and the court can then use his discretion.
That's it. Happens every day, no? You're right. Yeah. Let's hear, unless Mr. Ngomalo and Mr. Mshololo say you are wrong.
No, I'm not saying it's wrong.
No, no. Okay, fine. What do you say?
The court can use its own discretion on the application.
No, but you're not listening to Mr. Mnisi. Tell him what you said, Mr. Mtet. Tell him what you said. Repeat what you said. I don't think he understood you.
I understand.
Mr. Ngomalo, I mean Mr. Mnisi, yeah. Just repeat what you said before, just before now. By convention, that's the... No, no, no. Once you have said it, he'll understand it. He didn't catch you. I but him check.
I've said, my lord, by convention, there is no impediment on the part of the litigants to request the court or to make an application or to ask for indulgence from the court to record a particular witness. And then the court in those instances can then exercise their own discretion.
Okay, fine. Mr. Ngomalo,
I'll fall in the same trap, my lord.
you follow?
I agree with my colleague.
Okay, all right.
Yes, I agree with my colleague fully.
Ms. Mshololo?
My lord, both these provisions, they are very clear.
Deba?
They are very clear
Okay.
to say the court may. It doesn't say any party during the proceedings.
No, you've missed the ball again.
Yes, my lord.
The court, the duty rests with the court.
Yes, my lord.
Now, the incantation by the defense, when they realize that they want the court to exercise its discretion in terms of 167 and 186, can they argue and persuade the court to utilize that discretion which rests on the court? That's the question.
My lord, can I make my submission?
Yes.
Okay. My lord, my first submission is that the section is clear. 167 says the court may. 186 says the court may. That's my submission, my lord.
That's fine.
These two provisions says the court may. It doesn't say any party. However, my lord, if it is at the instance of any of the parties, either between the state or by the defense, the court must use its discretion.
Okay, fine.
Yes, those are my submissions, my lord.
Okay, thank you.
No,
Yes,
the
miss.
act, it's very clear to say it's the court, not by any party.
Okay, Mr.
Thank you.
Baloi, any new wisdom?
As a court, please, I go along with the submissions of all counsel. I think we're all ad idiom that any party can request the court to invoke these provisions.
Okay, what's the time now?
It's 11:05.
Yeah, okay, let's come at 11:30. 11:30. sorry, Exhibit O, 1 in brackets, Ms. Withlingham's affidavit dated the 16th of May, 2024, which is Exhibit J1. She sets out the transactions for 2 telephone calls, namely one made on the 2nd of August 2014 and one made also on the 15th of October 2014 between Ms. Kumalo's number, and these calls were received by, allegedly, or made by accused number 5. And further, that Lieutenant Stein locates the 2 calls at the time as the same as those which are reflected in section 205. Downloads of the cell phone numbers.
So lapha ku esikhombisweni o tho umama uVithilingam uthi kukhona ke izingcingo ezimbili olunye lwamhla 2 August 2014 olunye lomhla 15 October 2014 ezenziwa ke umsolosihlanu eshayela uKelly Khumalo, kodwa ke uKenneth Stein ubeka lezingcingo kungelezi ke ezavezwa ngaphansi kulombiko ophume ngesicelo sika section 205 sicela amafoni.
It is pertinent to mention that Lieutenant Colonel Stein testified, I think in August last year, and that Ms. Pinky Battlingham testified in July this year.
Ukufanele kuphinde kukhunjulwe ukuthi uBaba Stein balethe ubufakazi bakhe ngo-August kulonyaka odlule. Ms. Pinky Tillingham yena ulethe ubufakazi bakhe ngoJuly wanonyaka.
The state differentiates between the duties and titles as to what Ms. Pinky Vanningham's capacity is, and they refer to her as a supervisor in the Forensic Liaison Service section of Vodacom, whilst Stein is apparently referred to as an analyst of cell phone information.
Uthoke umshoshisi yana ubona kukhona umehluko phakathi kwemsebenzi owenziwa umama uVithilingam lo kuthiwa ke yena usupervisor we forensic liaison section yase Vodacom, kodwa ke uStein yena umsebenzi wakhe ukuhlaziya amafoni.
Mr. Baloyi, on behalf of the state, argues that this distinction is very vital because it is the one that allegedly brings about a dichotomy regarding its scope as practiced by either Ms. Pinky Vallingham and Lieutenant Stein, and says this very difference in the description of the expertise exercised by these 2 different witnesses has given rise to confusion, which the state says entails matters which are not clarified, and which the state further says when it argues that the defense says there is a contradiction relating to the 2 aspects of these 2 telephone calls.
Uthoke lana ke umshoshisi yana uthi ke lokhu kwehlukana endleleni ekusebenza ngayo mamVithilingam noBaba Stein ikona kwenza ukuthi kuvele kube kungathi khona ukwehlukana ngenxa yokuthi lokho kulethwa indlela abasebenza ngayo, ngokuthi umehluko lona wenza ukuthi ke kufanele ukuthi kube nokuchazwa kahle ukuthi yini indaba kube nalomehluko ngaka.
Further, the state argues that the crux of the matter also revolves around these two calls as reflected, one, in the PDF disk proffered to the state by Vodacom, and also what is referred to as the Excel spreadsheet, which encapsulated two different numbers, which are allegedly also supposed to have been sent or having been transacted between Kelly Khumalo and accused number 5. These numbers, as correctly stated by Mr. Nisi, they are dissimilar and they are materially different, or he says there are material differences. And also he goes further and says that difference, in his view, it was intended to pervert the course of justice. I'll leave it at that.
Into ke ebhekiwe lana ukuthi ke kukhona ke izingcingo ezabonakala lapha ku PDF evela kwa Vodacom naloko kubhawe kuloko kubizwa ngokuthi iExcel lapho ke izinamba ezimbili okuthiwa za kufonelana phakathi kwa Kelly Khumalo nomsolo wesihlanu kugcine kwenza ukuthi kube nokwehlukana okwenza ukuthi ke kube nobunzima ekutheni ukuthi kwamukele ngoba egcineni kubonakala sengathi kunobukhwabanisi obukhona la.
It is correct that Ms. Pinky Vithenium was not able to explain the origin of the two numbers of the two transactions allegedly transacted by Ms. Kelly Khumalo and accused number 5.
Kuyikona lokuthi ngempela umama Vithilingam akakwazanga impela yacaca ukuthi akakwazanga ukuthi achaze ukuthi yini indaba kuneyinamba ezimbili ekuthiwa zakhuluma noKelly Khumalo zivela kumsolo wesihlanu.
And these two numbers allegedly were made at the very same time as alleged by Ms. Pinky Villingham in the PDF disk supplied by Vodacom to the state or the police.
So lezi number ke za kwaba ingciko ezenzeka ngesikhathi esodwa njengoba kusho umama Vithilingam njengoba kubonakala kule PDF eyathunyelwa emaphoyiseni.
And she says she can only testify on the numbers which are encapsulated in the PDF disk.
Ukuthi ke Ms. Vithilingam yena angakwazi ukuchaza kuphela ukuthi kwenzekani kulezi number ezivela kule lombiko wePDF.
But she cannot testify as to the numbers which are encapsulated in the Excel spreadsheet.
Akakwazi ukuchaza lutho mayelana nenumber lezi ezivela kule spreadsheet se-Excel.
Because those were not supplied by Vodacom.
Ngoba lezo inumber ke lezo ke akuzona ezalethwa uVodacom.
The numbers which were supplied by Vodacom are encapsulated in the PDF disk, not in the Excel spreadsheet. I don't know how the police or the state went about transposing those numbers onto the Excel spreadsheet. She doesn't know. Two different distinctive application of the two surfaces, the PDF and the Excel system. She knows nothing about that. But in this court, we know that, as Mr. Nisi states there were two distinct numbers, two sets of distinct numbers relating to the two calls made allegedly to Kelly Khumalo by accused number 2 or vice versa.
So ke uma Vitilingam uthi yana into angayichaza kuphela yiloku okula kulombiko we-PDF akwazi ukuchaza lutho ngalokho kulapha kulombiko we-Excel ngoba lapha kubonakala ukuthi njengoba kuvelile phambi kwenkantolo kuneyinamba ezimbili ezehlukile ekuthiwa zazishayela inamba kaKelly Khumalo.
The state's contention is that well, not the allegation, the statements made by Advocate Nisi to the effect that there was fraud, there was uttering, defeating the ends of justice, or plain language, criminal activity intended to mislead this court and intended to pervert the course of justice, and consequently that charges would be laid or a complaint would be laid against even Pinky Wilthingham. And consequently, the state is of the view that these are very serious allegations which must be investigated. The allegations ought to be put to Colonel Lieutenant Steyn, and that he must be given the opportunity to comment because Pinky Willingham is being vilified for on her own mouth. She's being vilified for an action or conduct which she never participated in. And I have said that amounts to reputational damage because she's an expert witness. She gives evidence throughout the courts in South Africa. I first recall meeting her about 15 years back or so, or 20 years back in a criminal court. So I agree with the state when they say Steyn must come and account because Willingham can't be
Kuthiwa lana kukhona ke okubekiwe lana ukubekwe ngokuthi ke umshushisi uthi ke manje lezi zinsolo zokuthi kukhona ukukhwabanisa okwenziwayo futhi okunobugebengu lokhu kuthiwa kwenziwe Miss P Vitilingam kuthiwa lokhu kuyindaba esindayo efanele ke ukuthi ke ibhekisiswe and futhi ke kuyafanele ukuthi uSteyn eze azochaza ngoba lokhu phela kugcina kwehlise isithunzi sika Mama Vitilingam. Manje ke inkantolo yona iyavumelana nomshushisi ukuthi akabuye ubaba uSteyn ukuthi azochaza ukuthi yini inkinga phakathi kwalezi zitatimende.
Further, the state's contention is that this application is brought in order for Lieutenant Colonel Steyn to come and clarify the nature of these two calls.
So ke lokho uzama ukuthi ubaba uSteyn akeze azochaza ukuthi uhlobo luni lwazilezi ingcingo lezikhulunywa ngazo.
That accused number 5 allegedly is said to have made to Ms. Kelly Khumalo, that is, as to whether these calls were made using data or internet or whether they formed part of incoming or outgoing calls regarding AMA data.
Kuthiwa ke lana ke ubaba uSteyn ufanele eze azochaza ukuthi lezi ingcingo ekuthiwa zenziwa umsolo wesihlanu ziya kuKelly Khumalo zenziwa kusetshenziswana kwakusetshenziswa iData noma kwakusetshenziswa iInternet noma ke kwakuyingcingo ezingenayo noma izingcingo eziphumayo yini.
And this court is also baffled, I can tell you that, by the evidence given by Colonel Steyn, because this is what he says under cross-examination.
Jwana inkantolo nayo ididekile ngalokho kubekiwe la phambi kwale nkantolo manje nalezi ingcingo.
By Ms. Mshololo.
njengaloko kulethwe umama uMsholo.
On the question as to how did he establish that the various numbers that he mentioned in his affidavit are being associated with accused number 5, and this is what he said. That is correct, but also, I can also mention, after I received the information from Brigadier Gnanda, I throw it into the I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. That's how he explains it. To me, it's baffling.
Into esukeke idito ukuthi njengoba ivesileyo no Brigadier Gnanda ukuthi hayi uvela thathe konke lokuthola lena akufake lapha ku-AMB notebook, and yona ke esizochaza ukuthi kuxhumana kwalezi ngciko kwenzeka ngaluphi uhlobo.
And he never explained how he goes about this.
Futhi akachazanga ukuthi lokhu ukwenza kanjani.
It's like asking a Michelin chef in France, Paris, how does he prepare duck? And then he says, I throw it. I received the information from Brigadier Gnanda. I threw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phones downwards. That is explanation. I don't understand that people would cook. I don't.
Hayi jonga lendlela okuchazwa ngayo kufana nokuyobuza umpheki wase Paris okuthiwa ilolu hlobo lweMichelin, ukusho ukuthi uchwepheshe omkhulu okupheka ukuthi uma epheka ukupheka kanjani. Ngoba uma echazana ukuthi uvele ngithatha konke lo ngifaka emshinini lo we-AMB ebese ke ngithola imiphumela engiyidingayo.
So all the states he says wants to happen is that Lieutenant Stay must come and clarify the issue of the 2 calls, not to give new evidence. That's how I understand the application. And not to correct his evidence, to clarify his evidence. That's how the application is couched.
Manje ukuba umshushisi ukuthi into ecelwayo nje ukuthi uLieutenant Steyn akeze azoletha incazelo, hayi ukuzoletha ufakazi obusha, futhi kungekona ke ukuthi azolungisa amaphutha, ukuzochaza nje kuphela.
So the state says it is essential to recall Lieutenant Steyn in order to clarify this aspect so that the truth can be determined in order for the court to arrive at a just decision of the case.
Ke yikho kufanele uLieutenant Steyn ezazoletha incazelo ukuze ke iqiniso lizovela ukuze inkantolo izokwazi ukuthi ithathe isinqumo esinobulungiswa.
Okay, that is the gist of the application.
Kafushane ke isona ke lesi sicelo ekukhulunywa ngaso.
Now, Ms. Mchololos and the other counsel, if I'm correct, we try to define what are the duties of this court if it is approached or persuaded by a litigant, either the state or the defense, to say that because the court did not meromoto invoke 167, section 167, which I'll just read, and 186. I did not. I was entertaining an application.
Manje ke ubaba Msholola zamile ukuchazela inkantolo ukuthi yini umsebenzi wenkantolo uma kuukuthi abanye babameli abala inkantolo befaka isicelo sinjengalesi.
Now, this is what 167 says. The court may examine witnesses or persons in attendance. I'll just read it. The court may, at any stage of criminal proceedings, at any stage, meaning even at this stage, even though I never invoked it, This is what I understand it to mean. The court may, at any stage of criminal proceedings, meaning even during an application, like this one, examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and may recall and re-examine any person, including an accused, already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. And 186 says this, so that we keep that also in mind.
To inkantolo ke ithumi ichaza ukuthi 167 uthini yafunda inkantolo ethi inkantolo ingakwazi ukuthi nanoma ingasiphi isigaba so kuqhubeka kwecala ingakwazi ukuthi ihlole ubufakazi bananoma ubani obebiziwe ukuthi azoletha ubufakazi la enkantolo uma ukuthi lo bufakazi bungaletha ubulungiswa ekuqhubekeni kokuqulwa kwecala.
Section 186 says the court may subpoena witnesses. The court may, at any stage of criminal proceedings, subpoena or cause to be subpoenaed any person as a witness at such proceedings, and the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such witness appears to the court essential to the just decision of the court.
Jake section 186 yachaza ukuthi inkantolo ingabiza nanoma ubani ufakazi uma kuwukuthi ufakazi balo ufakazi buyadingeka ekutheni inkantolo ifike esinqweni sobulungiswa.
Okay. Sorry. Mr. Baloyi calls this application of his a rule of practice.
Babaloyi uthi ke lesicelo sakhe ke umthetho ohambelana nokuqhubeka kwendlela okwenziwa ngayo enkantolo.
Because according to him, it's not encapsulated as an application brought in terms of section 167 or 186.
Ngoba indlela achaza ngayo akusona isicelo esifaka ngaphansi kwesigaba 167 noma isigaba 186.
Sorry. Sorry, so much stuff here. I quote Dutoit and Jacher in their famous commentary on the Criminal Procedure Act. At page 2-95, under section, dealing with section 166, this is what the learned authors say. Recall for cross-examination. The right of the defense to recall a state witness for further cross-examination as part of a right to a fair trial was considered in S versus Rautenberg, 2014, 1 SACR, Johannesburg High Court, where the counsel wished to recall a witness because he had forgotten or had failed to put to a witness crucial aspects of an accused version for comment. This application was vigorously opposed by the state because, according to the state, the counsel's explanation for not having put these crucial aspects to the state witnesses regarding the accused version, the state held that they were not entirely satisfactory But despite this, the court allowed the witness to be recalled. Bear in mind that I said cross-examination. But what Mr. Baloyi wants to do is to recall a witness for clarification. And how do you clarify? It has to be an evidential phenomenon. It's got to talk about how he clarifies it. And a witness can either be called to testify, and then after he has testified, he is cross-examined, and after he's cross-examined, he can be re-examined. So logic tells you that this case of S versus Rautenberg 2014 is applicable here. 1 SACR GSK. It is by my brother and I dare say friend, Judge Bashir Vali. He was handling this case which regarded an accused who was charged with the murder of about 2 or 3 persons. He convicted this guy, and this matter was taken on appeal in Joburg, and I had the privilege of leading the bench, 3 bench. We upheld him, and they took us to the SCA, and the SCA upheld us. But this is what the learned judge has to say regarding cross-examination and examination and the recalling of witnesses. He says, recalling of a witness for cross-examination by accused counsel, who, in explaining that he was doing so as a result of the failure to put crucial aspects of an accused's version to a witness. And he said, the learned judge, the right to a fair trial determined and demanded the recall of a witness despite the unsatisfactory explanation given by his counsel. And he says, this is so because the right to a fair trial is absolute and indivisible. Let me quote him again. The right to recall a witness, that right encapsulates a right to a fair trial, and it is accorded to the accused by Section 35 of the Constitution. And that right is fundamental and absolute. And it is not subject to any qualifications. And the right includes the right to recall witnesses for further cross-examination, and by logic also, it entails the right to recall witnesses for further examination. Hence, despite the fact that the explanation given for wanting to recall the witness was not detailed enough and therefore not entirely satisfactory, the value in the application of this right was to be found in the duty of a court to ensure that the right of an accused to a fair trial is maintained in terms of its enunciation in Section 35 of the Constitution, and that it must be given its practical meaning, because this right to cross-examination also includes the right to re-examination and to the right to the recalling of a witness if it is in the interests of justice. And also this right to a fair trial includes a right to clarification and the right to an explanation with regards to the clarification of evidence. And this right also is encapsulated in the Constitution. I know people tend to talk of the Constitution as if it governs only the right to a fair trial as it pertains to an accused person. No, it also pertains to the state in having called witnesses. It's reciprocal. Section 35 as a right to a fair trial is reciprocal. And it was said also in the case of the National Director of Public Prosecutions versus King, 2010, 3 All South Africa, SA 304 SC. And it was enunciated by Harams. And this is what Harams had to say. It says the question, this is on paragraph 41. It says, it is well to remind oneself at the outset of a number of basic principles in approaching the matter. The Constitution calls for a generous interpretation in order to give effect to the fundamental rights and freedoms which it creates. The right to a fair trial is by virtue of the introductory words of Section 35(3) of the Bill of Rights, broader than those rights specifically conferred by the fair trial guarantee therein, and embraces a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning, whatever one wishes to attach the meaning to it. The question remains whether the right asserted is a right that is reasonably required for a fair trial. A general approach is called for. That is the question for the trial judge. And there is no general, not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make preliminary rulings depending on how the case unfolds, and may revoke or amend them. Irregularities do not therefore dictate that there is such a thing as perfect justice, which is a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in a criminal case must always be compromised. Fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but fairness also requires that the public should also be represented and be treated with fairness. It is represented by the state, obviously. This does not mean that the accused's rights should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of a fair trial provision is not to make it impractical to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems. Because after all, this is a court of law where justice must be seen to be done. Further, The learned authors also, Dutoit and Dijacher, say that the court has a duty to exercise the power to recall a witness where it is necessary to attempt to discover the truth in order that substantial justice is done between the parties. And they quote here the case of S. van der Berg, 1996, 1 SACR 19 is a Namibian case, and S versus Masowa, 2016, 2 SACR 22, Johannesburg High Court. It's a judgment written by Spelch, who still practices in this court. Further, sorry. Open that. I further refer to the case of S versus Gerbers, 1997, 2 SACR 601 SCA. It's a judgment written by Marais, J.A., who's famous for writing the judgment of State versus Malchus. This is what he has to say about the invocation of 166 and 186 of the Criminal Procedure Act when a matter comes before a particular court like today. And he says, by court, in terms of section 167 and 186 of the Criminal Procedure Act of 77, the principles governing the exercise of such power, a trial judge is not a mere umpire, but is bound to see that justice is done, whether the exercise of a discretionary power favors the state or the accused. The Court of Appeal does not readily interfere with the exercise of a trial judge's discretionary power. However, a trial judge has to bear in mind that bona fide efforts to do justice might be misconstrued as undue partisanship, and must ever, that is, the judge must ever try to find the right balance between undue judicial passivism and undue judicial intervention. The basic principles which govern the discretion of a judge under 167 and 186 of the Criminal Procedure Act is time-worn but remains as valid today. That is, it is time-worn in the case of R versus Hepworth, 1928 AD 265. But this law has not been changed right up to today. Still valid. And this is what the learned judge has to say about this time proven law. A criminal trial was not a game where one side was entitled to claim the benefit of any mistake or omission. Harams calls it a predilection for ingenuity. By the other side, a judge's position in a criminal trial was not merely that of a mere umpire to see that the rules are observed by both sides. A judge has to see that justice was done. The power and discretion under these mentioned sections could be exercised by a judge, whether the effect thereof is in favor of the state or the accused person, provided that what is done is for the purpose of doing justice as between the prosecution and the accused. Further, the mere existence of those discretionary powers did not preclude a finding that a trial judge had exercised them irregularly, as that word was understood in the jurisprudence of criminal procedure, nor did it follow from mere existence of a positive statutory duty to exercise those powers in circumstances where it appeared essential to the just decision of the case, that a trial judge's conclusion and that the circumstances were indeed such that these discretionary powers would be unassailable by a higher court. But basically what they are saying, once a judge has exercised this discretion, all he has got to do is to exercise a judicial discretion. Whether he's right or wrong, that's another story. That's why they say it would not be unassailable by a higher court, and that no matter what the circumstances might have been, his carrying out of what he perceived to be his duty could never constitute an irregularity. It's not me saying that. You can read this case. Further, a court of appeal should remind itself that there were well-known limits to its power to gainsay the bona fide exercise of a trial judge, whose discretion vests in judicial discretion. With regard to the conclusion of a trial, that it was his duty bound, he was duty bound to exercise the powers under consideration. The Court of Appeal should not lightly substitute its own opinion, reached with the benefit of hindsight. And the learned court also says that there is obviously a potential tension between the need to fulfill the role of a judicial officer, as described in Hepworth's case, and the need to avoid conduct which was irregular and resulted in the failure of justice. Nevertheless, it remains incumbent upon all judicial officers constantly to bear in mind that their bona fide efforts to do justice might be misconstrued by one or other of the parties as undue partisanship, and that, difficult as it might sometimes be to find the right balance between undue judicial pessimism and undue judicial intervention, they have ever to strive to do that. Right? In this court, there was an exercise of the same power of the discretion by a judge. My brother Motata was involved in that case. I'll read it. Sorry, it's a written. Maybe some of us know that case, but this is what was said in that case. This was a case of the Director of Public Prosecutions, Transvaal versus Eric Pet Mchweni. This is case number 56/06. It was heard in this court, in this SCA by Judges Falam, Klute and Lewis. And this case also concerned ballistic evidence. But if you're interested in reading the full text, you can do so. But it's basically the following. This judge, my brother, Seriti, were together at Forte, he misconceived and misconstrued the evidence where ballistic expert had said it was indeterminate whether this particular firearm had fired the projectile. When they examined that firearm, it did not have indentations imprinted onto the bullet. So this gentleman said his finding that this firearm was the one which was used to shoot the accused person twice on his face cannot be determined. It's indeterminate. And Judge Seriti wanted to know, the defense of this gentleman is that he was shot in Harangua, not here in Brits on a farm. Okay, there was DNA evidence showing that after he was shot, his blood dripped onto the yard, and the DNA obviously connected him to that. But this is what the judge says. 3 judges. In my view, it is clear from the record that Seriti J. did believe that the evidence of the ballistic expert was essential to the just decision of the case. And he acquitted Mthweni because there was no explanation of the inclusiveness of the finding. And the 3 judges says, he had a duty in view of his belief that it was essential to the just decision of the case himself to call the witness, like I'm called by the state to call this witness. Moreover, it is apparent from the passages of the argument quoted above that Seriti did not understand the import of the ballistic report. I don't understand that evidence of a stain saying he just mixes A and A, etc., and he gets the results. I don't understand it. Same thing with Seriti here. But he did not recall, he did not call for that evidence or explanation. So they say, moreover, it is apparent from the passage of the argument quoted above that the Seriti did not understand the import of the ballistic report. He said as much, as I'm saying as much. All the more so, therefore, that he had an obligation to call the witness in order to understand that evidence. He was obliged in terms of section 186, and thus as a matter of law to have acted in terms of the section. And this is the summary of the finding. Where the presiding judge at a trial believes, where the presiding judge at a trial believes, albeit mistakenly, that the evidence of a witness is essential to the just decision of the case, in terms of section 186 of the Criminal Procedure Act 51 of 77, it falls to call, if he fails to call such a witness, he makes an error of law. That's what they're saying I'll be doing. If he fails to call such a witness, he makes an error of law. If the error is one of which the acquittal of an accused tends, then there is a grave irregularity in the proceedings, and the Court of Appeal is bound to order a retrial on the same charge sheet. Here, a question of law was reserved for argument in the SCA. This is what the SCA says. You rather err on the side of being wrong. Here's a judge. He was confronted with a similar situation. He said, no, I'm not calling this guy. And then the state said, please call him so that he can come and clarify. Then they noted the point in terms of section 319. On appeal, they succeeded. Okay. Further, I just want to quote the other case and then sorry. Sorry, I just want to sort out this case. Sorry. Yeah, in the case of S versus Nobo, 1999, 3 Constitutional Court, although then they called it BCLR 298, but it was a Constitutional Court decision. It says, section 186, envisages, in plain language, a partly inquisitorial approach. The court has a duty to exercise the power where it is necessary to attempt to discover the truth in order that justice be done between the prosecutor and the accused, so long as the questioning remains within the bounds stated in the case of S versus Roll, 1982-1. Yeah. Sorry, let's just do the last case now. Right, just to adumbrate the point made by R versus Hepworth. In this case, after the learned judges had quoted the case of R versus Hepworth, in the case which is unreported of State versus Ngobeni, 2014, it's a it says SCA case, it's unreported, but it is case number 741/13. It was heard on the 2nd of May, 2014. Busielo J.A., who was my article clerk in 1982, in a dissenting judgment, accepted the dictum of Kerr Lewis J.A. in Hepworth and said that it is salutary because it introduces an inquisitorial element to a fundamentally adversarial criminal justice system. And he added that this was, however, intended to avert the possibility of an injustice which might occur should a court remain supine in the face of a need to be proactive and to obtain the necessary evidence. A court had nevertheless to be astute to avoid creating the impression that it has descended into the arena, which was impermissible and should result in this court getting involved in the dust of the conflict between the prosecution and the defense, with the concomitant loss of impartiality, an essential prerequisite for a fair trial. Busielo J. considered that it was important to remind judicial officers presiding over criminal trials that there are times when justice demands that instead of remaining passive umpires, merely there to ensure that the rules of the game are observed, that they have to be proactive without compromising their impartiality, to call for the relevant evidence, particularly where they are of the view that such evidence is necessary to ensure a just outcome. This was also the opinion of the judge. And he says that is the reason, the trait of section 186. So all the authorities are saying to me, you have listened, they're saying to me I don't have to be supine. I've got to be proactive where I think that justice will fail if I don't make such, I don't entertain such an application. They are actually saying, I will be committing an irregularity. It's not me saying that. 5 judges of the SCA quoted to the case of Mchweni. So it's settled law that if it is within the reasons of logic, there is an argument between the state and the defense regarding whether evidence has to be corrected or clarified, or evidence in the administration of justice can never ever happen. They say the judge should err on the side of the application. And I've already conceded that I don't understand what Steyn was saying there. Never explained it to this court. I don't understand. And the state says it's not a contradiction. It is a misunderstanding, a misconception. So here we have a misconception, a misunderstanding, a contradiction, and a non-understanding, all from persons in this room. So why not call the person who is causing that very misunderstanding, misconception, to come and explain, and is alive. And there's no prejudice, by the way, none. When he comes here and perjures himself, this court can even charge him with perjury, Steyn. If he comes here and perjures himself, there are criminal consequences. But it doesn't matter which way he comes and testify. For this court, the truth must be told. And there's only one person who can tell the truth about this. It's Steyn himself. He's the analyst, not me, not Mr. Mumalo or Mr. Baloyi. Consequently, the application is acceded to. Yeah.
Yes. May I just request to establish something after the order of the court,
Fine.
after the ruling of the court? In this clarification purpose, will it not invite new facts, because we are not sure what Steyn is going to say?
Yeah.
And I was appealing to the court to guard against new facts, because that will not serve the purpose
Yes, yes,
for
you're
which
right.
Section
You're right,
167
you're right.
Court, please.
Mr. Mnisi says, actually, if it's on new evidence, it's okay. Is that not what you said, sir?
I just missed the court, madam.
You said if it's new evidence, you'd understand.
I really did not mean it in that context.
Okay, fine, fine. No, there are parameters to what Steyn can come here and tell us. He has already given evidence. He's just here to clarify. So it's not like he starts by telling me that he was an analyst employed by the Ruperts, blah, 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 blah. No. It's circumscribed. This application is circumscribed. According to Baloyi, it's on 3 aspects. Am I right, sir? It's circumscribed to come and clarify.
Indeed, my lord.
That's
but-
what you say.
Yes, indeed, my lord. But
So
you
I'm
might-
saying there's no prejudice to anybody. This witness will be taken into cross-examination. Because like I have said, and as we all know, Ms. Pinky Thallingham knows nothing about that parcel spreadsheet. Knows nothing. She never participated in it.
As well.
Yeah.
In the light of the court's ruling and in the light of what I had previously asked the witness, Ms. Linden,
Was it?
I asked Ms. Put a proposition, in fact, to her.
Yeah.
And my learned colleague, Mr. Sibanda, objected to say, Mr. Stein didn't say so. Will that now be an opportunity also to
Yes.
clarify those
Yeah,
aspects?
you can.
I'm happy, Madam. Thank
Yeah.
you. I mean, that's it.
Mr. Stein, Mr. Sibanda, and Mr. Baluya are one and the same. Is that not so, sir? What is said by your colleague is said by
Yes,
you.
indeed, my lord.
That's why mina
yeah.
nguBaluya, I'm still staying.
We just want to point out that in clarification of those issues, there might be documents that will be used just to demonstrate, to be used in clarification.
Yeah, I know.
Yes, yes.
It's a clarification. I don't know what Stein is going to, Stein is going to say. Me, I never understood him. You just take A and B and you do this and you come out. That's all he said. So he'll come and tell us exactly what he did. Okay.
Yes, if we may perhaps adjourn us, it's about 20 to 1, just to show the documents that Colonel Stein will be using to my colleagues and just agree on the way forward. Maybe we can resume at 2.
Any objection? I don't have to see those documents. But he wants to show you those documents. Hello?
There are documents that the state would love to share with us, madam.
Yeah, I don't know what.
Yes, madam.
Lord, may I also take a minute just to summarize?
Yeah, summarize for the
Inkantolo ke ibhekile section 167 section 176 mayelana phela nokubuyiswa kokafakazi ebuyiselwa ukuthi ke azocacisa okuthize. Inkantolo ibheke lapha incwadi yabhala uDutoit noDiyaka mayelana neCriminal Procedure Act. Lapha ke kuveziwe ukuthi kuyabonakala emacaleni njengecala lika Rautenbach elaba segoli la ichazwa khona kabanzana ngokuthi ke inkantolo ingenzani. Bakhona okuningi okubekiwe enkantolo ukuthi cha inkantolo kubekwa amacala amaningi achaza ukuthi inkantolo iyebhekane nezimo ezinjena zolapho ekufanele khona inkantolo ibuyise ufakazi ukuthi azoletha ubufakazi bokuchaza futhi. So ke inkantolo wavezile amacala amaningi lapho amajaji ayeveza khona ukuthi inkantolo izobe ingawenzi umsebenzi wayo uma kuwukuthi ayilethi ufakazi ukuthi azoletha futhi ubufakazi ngoba lokho kuzobe kuletha ubulungiswa. Ngakho inkantolo ithatha isinqumo sokuthi lo ufakazi okuceliwe ukuthi akaphinda abuyise uzobuyiswa enkantolo ukuthi azoletha lo bufakazi. As the court pleases.
Okay, so we come back at 2, is it?
Akere kona ile Pastor Mbongo.
Yeah.
The state calls former Lieutenant Colonel or retired Lieutenant Colonel L. Stein.
Yeah. Thank you. Yes.
Sorry to interrupt, with due respect to the state. Mr. Stein takes the stage and start to present whatever he's been called for to come present. We've just been handed out with some documents by the state. We cannot make sense of what these documents are. The state is also not in a position to explain to us what these documents are. So now the challenge that I have with accused number 3 is that from where I'm standing, this constitutes new evidence, which the court has ruled that it won't be part of this process. Because now if these documents were already there when this witness came and proffered his testimony initially, they should have been made available to us, such that his explanation for whatever that he has come to explain today should also be based on the documents that are already forming part of the court record. Now we've got new information that the state wants to introduce through the back door. It has not been explained to us that what is the purpose of this document. Why were they not introduced initially when this witness came to proffer his testimony? Why now?
Are you through, sir?
I'm not even so sure, my lord, whether if I make an application that the testimony of this witness should be stood down so that I go and make a sense of what these documents are. Whether I'll basically come to an understanding of what these documents are. Because they're just typewritten documents. Where do they come from? I don't know. Who prepared these documents? I don't know. But the gist of the matter is, they constitute new evidence. They do not serve, from where I'm standing, to explain or to give an explanation that the state said, to give the clarification that the state said this witness is called for to come and allude to. But another thing, my lord, I need to consult with accused, with my client, make a sense of what these documents are, because this case is not about me, it's about him. This is not my case, it is his case. Find out from him whether he does understand what the import of these documents are, in fact what these documents are, even before this witness starts to proffer his testimony, because it will be useless for me, not really useless, it will be a fruitless exercise for me to say, like, let this witness start to proffer his testimony and then thereafter I'll go and understand what these documents are. Because as he will be testifying, most probably the state will be referring to him to these documents that I am making a submission that this constitutes new evidence. And the court has, in no uncertain terms, indicated that no new evidence is going to be entertained in this application.
Yes, Mr. Bloy?
As a court, please, my lord.
What are these documents for?
We'll get to that, my lord. The parameters of this witness evidence are circumscribed.
Yeah.
It is mainly, it is exclusively to explain the information that is on page 23, 26, and 27 of his affidavit.
Okay.
Now, obviously, that cannot happen in vacuum. He's going to use certain documents to explain that. We did mention that before the adjournment. And we handed the documents to the defense during the adjournment, and I did explain to the defense what the documents are all about. There was only one document that we just needed confirmation on. But all the documents were explained, and I'll go through. No, the court doesn't have the documents there.
No,
but
fine.
The first document, my lord, we've marked the exhibit K1.
No, wait.
Yes.
Are these the documents which Colonel, Lieutenant Colonel Steyn is going to use
Yes.
in clarification.
Indeed, my lord.
Is it true, Colonel?
But it's also been mentioned in my old statement.
Yes.
Hello?
In my
Yes.
first statement, I
Yeah.
did make mention of it.
Yes.
Yeah.
This is just part of the download to show to the court what it is.
So according to you, these documents it's not new evidence.
That's not new.
It's not new evidence.
Yes,
Right.
we get into that point, my lord. If I can just quickly explain.
Okay, fine. Now I want to know, this witness is an expert witness, understands what
Yes,
you're
on
saying.
page 18 of his affidavit, exhibit 01,
Yeah.
there's reference to the fact that the cell phone of Ms. Kelly Kumalo was rebooted.
Yeah.
And there is a document that proves that. Exhibit KK1 is merely a download of that document to indicate that the phone was rebooted. Then a document that we've marked exhibit KK2, this is the, it's simply an index or the contact list of the phone of Ms. Kelly Kumalo, which is already on record. KK3 is the document that I said that initially we wanted to get more information on when I was explaining to the defense, just simply indicate it's like an index, the contents of what was on the phone. Then exhibit KK4, this is a list of the telephone numbers that were on the phone of Ms. Kelly Kumalo, which this also serves already as an exhibit before court. Then exhibit, and it shows the 2 dates, information regarding the 2 dates in question. Then exhibit KK5, this is an extract of the information that we've already furnished to the defense. This is part of Ms. Filligam's document. The information was finished electronically to the defense. In fact, it forms now part of J1. What we did is just to extract 2 pages pertaining to the 2 dates, and these pages form part of the documents that were handed to the defense. And this is the sum total of all the documents, my lord. This is nothing new.
Yeah,
It's
okay.
what was already on record.
Does the defense need more time to study the documents? Ms. Ngomezulu,
My lord,
do you need more time to study these documents?
firstly, before I
Yeah.
answer the court's question,
Yeah.
there's something that actually puzzles me
Yeah.
regarding this evidence to be laid by the state.
Mm.
An application was brought by the state to reopen the case,
Not to reopen the case.
to seek clarity.
That's it.
Yes,
Yes.
that's what I want to.
Yes.
But in that application, it has never been mentioned as to how that clarification was.
That's the
going
point. This is the
Yes.
witness who's going to clarify. The
May
court is in the dark like me.
May I address the court?
Yeah.
There was no, in the application itself, it was not stated as to how such clarification was going to be elicited in this court, either orally or in terms of documentation.
That's right. It was
So
never-
now we are finished with more than 20 documents,
Yeah.
more than 15 pages.
Yeah.
We haven't consulted with our clients.
Yeah. Not quite.
And my
That's a
lord-
fair comment.
I've requested that the state, in seeking this clarity, will it not invite new evidence? But looking at the papers that were given, it shows that there's something new that will crop up.
Hello?
Something new that will crop up here.
I don't know.
That's what I foresee.
You're a prophet.
I'm a prophet.
Yeah. You foresee.
I'm a
it.
legal expert.
No. I'm not being cynical.
No,
You
I'm
say
a-
this is what you foresee.
That's what I foresee.
If you foresee something,
Yes.
yeah.
From the look of things, my lord, look, my lord, let us be genuine. If I'm saying the state, you know, there's something that I'm concerned about. The state brought an application, we didn't oppose it. We are fine. Not that we're doing the state a favor for not opposing it. But the state should be transparent enough to the defense. They should tell us in their application that we intend to clarify this part of evidence by tendering certain documents in order for us to clarify the concern that each party has. But this now, the state, as it always the position, they like to take us by surprises. They always take us by surprises. We don't want to listen to this evidence until we are satisfied with this document.
Is that how a lawyer speaks? You don't want to listen to this evidence?
Of this witness.
You don't want to?
We don't want to listen to it before we get into knowing what is in these documents.
But Mr. Baloy says he explained.
But my lord, is it genuine enough or fair enough?
I don't know.
No, but this is what I'm submitting to the court. You bring an application. You say you sought to clarity on this part of, but you don't state that this clarity will be expressed in the form of oral evidence or documentary evidence. Now you give us documents, then you want to lead evidence. That's not fair for the defense. That's not fair for the accused. Every time we need to succumb to all the requests that the state is making.
Sir, are you available tomorrow?
Yes, available tomorrow, but I'm going back on Thursday.
Oh, sorry about that. Oh, tomorrow is what, Wednesday?
Wednesday.
What time are you going away on Wednesday?
On Thursday, 11 o'clock.
In the morning?
Yes, sir.
The court is prepared that you should study the documents that you say you want to study them. How long do you need for that? This witness, I can prevail on him to come on Monday next week, so that nobody says we were taken by ambush. Are you available next week, Monday?
I'm available, but you must keep in mind it's a long weekend.
I know. Oh, no, the weekend starts on Friday.
Yeah, but to get back to Joburg.
Oh, you'll be back on what? Where?
In the Western Cape, in George.
Yeah, in George, but I'm saying on Monday. Is it a holiday?
No, it's Friday's holiday.
Yeah, Friday. No, I'm saying.
So if there's a plane available, I'm available.
On Monday.
Yes.
Yeah, this court is preparing to postpone the case on Monday, to Monday next week. And then I can postpone it for you to be apprised of the documentation, because this witness says, I don't want to say, they say I'm putting words into your mouth. Is that the clarification documents you're going to use?
That's correct, yes.
Those documents are in clarification.
That's correct.
Of your evidence which you led here.
That's correct.
Right. Okay.
May I request something, my lord? I'm not speaking on behalf of all the defense, but that's my request. I'd request the same exercise that was done by
the what?
Colonel Khoos when he filed a supplementary affidavit. I request that his clarification in my own request, that such clarification be also reduced into writing. To be reduced into writing in a form of an affidavit.
You are prepared to do that?
And incorporate all these documents.
I can do it, man.
And when can you bring that clarification? Because if you do it in the form of an affidavit, are you saying he must also come to court? You must say
Mr. Khoos did come to court.
No, I'm not talking about Mr. Khoos.
No.
I'm not talking about Mr. Khoos. I'm talking about this gentleman.
He must also come to court.
If he does it in an affidavit,
he must also come.
To court. Are you saying you'll do that?
Yes.
Okay. Right. How many days do you need for his affidavit? 2 weeks, 2 years?
My lord, on my side, I just need overnight to go through the documents. We can proceed tomorrow. On my side.
Yeah, no. On your side, how many?
I also need it overnight.
And then the witness must come on Thursday.
Tomorrow, it's Wednesday.
Yeah.
He can
and then
come
the witness
tomorrow.
must come on Wednesday. Thursday he says he's not available.
Tomorrow.
Yeah, he says he's got to be back home on Thursday.
Tomorrow the witness is
You know, I quoted you guys a case which says litigants should not make it impractical for a case to go on. I want to quote it again. Yeah. Where's that judgment of the Director of Public Prosecutions versus, I don't know, somebody takes my cases here. Maybe it's still here. Oh, here it is. Let me quote you what these guys say, not me. 5 judges of the High Court, of the Supreme Court. It's Harams, who was the Deputy Judge President, Malan, who used to be my colleague in Joburg, Mlambo, who is now my JP, Nugent, and Majid, who's now in the, Majid is in the Constitutional Court. Nugent is retired. He was an SCA judge. Lambo is still around. Malan is retired. Harams is retired. It's 1, 2, 3, 4, 5 judges. It's not me saying that. 5 judges of the SCA. You may be seated, sir. Because we gaan nie getuig vandag. Fairness. This is the case of National Director of Public Prosecution versus King, 2010, number 3 volume, all South Africa, page 304, South African SCA, Supreme Court of Appeals. This judgment was delivered on the 8th of March 2010. And this is what it says, amongst other things. It is well, that's paragraph 41. Paragraph 4 of page 315. And this was a unanimous decision. There was no dissenting decision. 5 judges agreeing. It is well to remind just to give it a bit of context, let's study it at paragraph 3. Paragraph 2, the blanket privilege, meaning the submission or the privilege of granting documents in terms of State versus Chabalala, which is a constitutional court case. The blanket privilege has not been replaced by a blanket right to every bit of information in the heads of the prosecution. Litigation privilege does still exist, also in criminal cases, albeit in an attenuated form as a result of these limitations. Litigation privilege is in essence concerned with what is sometimes called work products, and consists of documents that are, by their very nature, irrelevant because they do not compromise evidence or information relevant to the prosecution or defense. This much is hardly contentious. What is in contention in this appeal is whether an accused is entitled as of right to a full description of each and every document to which he is denied access, all being documents falling within parts B and C of the docket. with a statement of the precise basis upon which access is denied to any document in order to have a fair trial. In other words, is the accused entitled to a motivated index to satisfy him in advance that a trial will be fair? The court below held in the affirmative, and hence this appeal of the National Director of Public Prosecution. It is well to remind oneself at the outset of a number of basic principles in approaching the matter. Constitutions call for a generous interpretation in order to give effect to the fundamental rights and freedoms that they create. The right to a fair trial is by virtue of the introductory words of Section 35(3) of the Bill of Rights, broader than those rights specifically conferred by the fair trial guarantee therein, and embrace a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning whatsoever one wishes it to mean. The question remains whether the right asserted is a right that is reasonably required for a fair trial. A generous approach is called for. A generous approach is called for. This is a question for the trial judge, and there is, in general, not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make preliminary rulings depending on how the case unfolds, and may revoke or amend them. Irregularies do not lead necessarily to a failure of justice. There is no such thing as perfect justice. A system where an accused person should be shown every scintilla of information that might be useful to his defense and discovery in criminal cases must always be a compromise. Fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that an accused's rights should be subordinated to the public's interest in the protection or suppression of crime. However, the purpose of a fair trial provision is not to make it impractical to conduct a prosecution. I repeat. However, the purpose of a fair trial provision is not to make it impractical. It is not made to make it impracticable, which is stronger than impractical. It is not to make it impracticable to conduct a prosecution. The fair right does not mean a predilection for technical niceties and ingenious legal stratagems. To the contrary, courts should further be aware that a person, well, that talks about people who are charged with white-collar crimes. This is what 5 judges say, not me. It's not me. 5 judges. You haven't listened to this witness. You don't even know what he's going to say. You don't want to listen to that evidence. Okay, the law is clear. I have to hear and listen to you, even if you have those documents. I don't know how you're going to explain it. They also don't know. They must read the documents first. And you know what? If you don't understand him, go and consult an expert. Like I broke my back. You can ask the JP. 8 months, I gave you the right to consult an expert, ballistic expert. You have the right to do that. If it takes us 3 years, please do it. Go and get an analyst. Okay? No, I don't want to talk to you, sir. Please. I'm just telling you.
wanted to make a submission regarding
What?
as to when we are coming back, my lord.
We're
My
coming
lord,
back on Monday. Okay, is that okay, Monday, Mr.? In the meantime, you've got to call a witness tomorrow, sir. Okay.
My lord, we don't have any witness line up for tomorrow.
And then Thursday?
Thursday, it's a difficult day, but my understanding of my learned colleagues is that they just need time overnight that we can proceed tomorrow. That's my
But this
understanding.
witness is not available on Thursday.
Yeah, but tomorrow is Wednesday. We can proceed tomorrow.
Do what? Read the documents in his absence.
No. He's going to testify. It's Wednesday tomorrow. He is
Well,
available.
Mr. Mnisi says he can't make head or tail of this document. It's not me saying that. He says that. Doesn't know what this document is here for.
No, I think the court misunderstood.
No, I did not, sir. I did not.
I never suggested that.
You didn't
we should-
suggest it.
As a result of that, we should therefore come back on.
No, that's never, you never suggested it. But you are saying these documents, 10 or 15 of them, you don't know what they're talking about. You are in the dark. That's it. So I'm giving you enough time, wait. I'm giving you enough time until Monday to appraise yourself of these documents. And I'm saying, if necessary, go and consult an expert, analyst, concerning Section 22, downloaded documents.
Subject to the court's approval, can we make a suggestion that maybe we adjourn until tomorrow? See if they can wrap their heads around the document. And if needs be, perhaps we can adjourn until Monday, but let's adjourn
Yeah,
until
because this
tomorrow.
witness is going to write an affidavit.
Yes.
You've forgotten about that.
Oh, yes, yeah, that's
Please.
another thing.
Done and then just finish up, I can do it tonight.
Have you finished that affidavit?
It's 90% finished.
Which you wrote it without listening to what you're supposed to explain.
That's correct.
Hello?
I listened to the radio.
Hello? Yeah, I'm telling you what I know about law. You haven't listened to the questions which he's going to ask you in clarification. But you already want to make an affidavit.
But my affidavit is just around the fact that,
Yeah, fine, I understand it. I understand. But I'm just saying, you are told to write an affidavit on what?
to clarify the difference between a download and a Section 205.
And what else?
Because the way I understand it, the way Pinky put it in court, before court, it's nothing to do with a download, because the download belongs to the police. And at this stage, I think they're all under the impression that I only work on one document. So I just want to make it clear to the
You work on
court.
several documents.
Yes,
Hello?
yes, I work on several.
Several documents. This system you're going to explain it to me, because I don't want to pretend knowledge. They call it the what? The Excel
Excel
spreadsheet.
Yeah, the Excel spreadsheet.
Spreadsheet. How many documents do you use for that?
I use the Section 205 of Vodacom, and I use the download.
That's
I do
it.
that too.
Okay, so Monday, is it okay Monday, sir?
It's fine.
Yeah, Monday. So that nobody can complain of not having sufficient time. Okay, and then the affidavit, you will bring it on Monday.
Yes, I can bring it to you.
Okay, the court will adjourn until Monday.